Uttarakhand has become the first state in the country to give legal backing to live-in relationships, making it mandatory for residents to register such unions with the authorities. The proposed guidelines, part of the state's Draft Uniform Civil Code (UCC), also suggests a fine as well as imprisonment of up to 6 months for live-in couples who fail to register their relationship. I will break this down for you along with key provisions of the bill. Live-in relationship. The proposed guidelines, part of the state's Draft Uniform Civil Code (UCC), also suggests a fine as well as imprisonment of up to 6 months for live-in couples who fail to register their relationship. The bill makes it obligatory for partners to a live-in relationship within a state, whether they are resident of Uttarakhand or not, to submit a statement of live-in relationship under subsection 1 of section 381 to the registrar within whose jurisdiction they are living. It also says the registration to be made at the time the live-in arrangement begins is simply for record-keeping purposes. The registrar, who will serve as the nodal authority for these registrations, will be appointed by the government through a notification in the Uttarakhand Gazette, the draft adds. Among other things, the law provides for maintenance if a woman gets deserted by her live-in partner, to be pursued through courts. It also states that any child born out of a live-in relationship shall be considered a legitimate child of the couple. The proposed law doesn't allow registration of prohibited relationships, including those where one or both of the partners are minors or where the consent of one of the partners was obtained by force. The draft also seeks to empower the registrar to refuse registration if one of the parties is already in another live-in relationship or marriage, or consent is obtained by force, fraud, among others. The statements of live-in relationships submitted will be forwarded by the registrar to the officer in charge of the local police also. In case either of the partners is less than 21 years of age, the registrar will also inform their parents and guardians, the draft further states. If the registrar finds that the statement provided is incorrect or suspicious, the officer in charge of the local police will also be informed to take appropriate action. The draft points out that even residents based outside Uttarakhand may submit a statement of their live-in relationship, though it is not mandatory. The second provision. Provisions of the UCC bill do not apply to the tribal communities. Personal laws in India are quite complex, with each religion following its specific regulations. The idea behind UCC is, the Uttarakhand government says, to have a common set of laws on marriage, divorce and inheritance that would be applicable to all irrespective of religion, rather than the community-specific personal laws that presently govern such matters. However, this bill's provision will not apply to the tribal communities. The bill says, and I quote, "Nothing contained in this code shall apply to the members of any scheduled tribes within the meaning of clause 25 of Article 366, read with Article 142 of the Constitution of India, and the persons and group of persons whose customary rights are protected under Part 21 of the Constitution of India." The third provision, which is the Uttarakhand UCC bill, does not allow more than one marriage, thereby banning polygamy and criminalising Halala. Nikah halala is a practice in which a woman, after being divorced by triple talaq, which is divorce, marries another man, consummates the marriage and gets divorced again in order to be able to remarry her former husband. The bill has suggested a uniform marriage age for both genders, irrespective of religion. Setting up condition for solemnizing contracting marriage, the section 4 of the bill states that a marriage may be solemnized or contracted between a man and a woman if the following conditions are fulfilled, which is namely, neither party has a spouse living at the time of the marriage, thus prohibiting bigamy or polygamy. Fourth, the bill retains the custom exception from the Hindu Marriage Act for married parties within the degrees of prohibited relationships. The bill has also proposed uniform marriage age of men and women across religions, while also listing degrees for prohibited relationship. The marriageable age for men and women remains 21 and 18 respectively. Under the condition for marriage provision, the bill has retained the custom exception from the Hindu Marriage Act for married parties within the degrees of prohibited relationships. There is exemption for those marriages between parties within the degree of prohibited relationships if the custom or usage governing one of them permits marriage between the two. However, These customs and usage, the code points out, should not be against public policy or morality. That's all I have for you now. Do follow our updates as well as videos on our YouTube channel.